Hey everyone, recording on my phone because we actually have a huge court case win in the lawsuit that I am a plaintiff in Boland versus Bonta, challenging the state's handgun roster. I was not expecting this to happen today, so I am actually in Texas right now, just competed in the tactical games, hanging out with a buddy of mine. So I'm having a great weekend, having a great start to this week, and I hope you are as well. I want to talk to you today about the motion for preliminary injunction being granted by the judge in our court case, Boland versus Bonta, and how this can potentially get rid of the state's handgun roster. Now, as we all know, court cases take a long time to fight. This is a long fight in the future, but starting off on a win is always a better way to start, and I think this is a great sign to show the progress that we're going to make. We know that the Ninth Circuit Court of Appeals, when they heard Miller, Duncan, Rody, and many other cases, they all shifted those back down to Benitez. Now, my personal opinion is that they shifted those back down to Benitez because they knew that they were not going to be able to uphold the state's bans on a various type of firearms, ammunition, and that sort of thing. So this is likely going to get appealed to the Ninth Circuit, but I wanted to read to you some highlight points and discuss some of the things in this court case and what we're challenging. So our motion for preliminary injunction was to get rid of microstamping, was to get rid of loaded chamber indicators, and to get rid of magazine disconnect mechanisms. Now, microstamping, for those of you that don't know, is a technology that technically exists and is not being held up by any patents, but as testified in the court case, is not practical or possible to be implemented on a wide-scale manufacturer basis because it would require each firearm to imply or imprint onto the primer of the gun an individual serial number that identifies it to that gun. Regardless of how easy it would be to defeat that with a simple piece of sandpaper or a hand file, the technology is just too cost prohibitive, and it is because of that it has not been implemented, in addition to the market simply not wanting it. Supply, demand. There is zero demand for this product. Therefore, the supply is not worthy of investing millions and millions of dollars per firearm to make that technology work on every different type of gun and ammunition combination. So, like I said, we did get the motion for preliminary injunction. I want to read to you from the intro of this, and now keep in mind the entire link to this is going to be in the description down below. I want to give a big thanks to the CRPA, Michelle and Associates, and all the lawyers that worked on this. Check them out. It's worth donating because they are doing good work. So from the intro, the judge said, because of the plain text of the Second Amendment covers plaintiffs' proposed course of conduct of purchasing state-of-the-art handguns and the unsafe handguns, chamber load indicator, magazine disconnect mechanism, and microstamping requirements are not consistent with this nation's historical tradition of firearm regulation, plaintiff's motion is granted. Now, Heller actually set that sort of test. The state of California in the Ninth Circuit was using a two-part test of saying, hey, means end. They were trying to say, we're trying to ban these unsafe guns, and we think that will be making the world a safer place. And they were able to get away with upholding any law they wanted, even if it wasn't actually going to do anything, like the Unsafe Handgun Act. Now, Bruen further clarified that you have to use text, history, and tradition as the test. Is there a historical analog for this back in the day? Is there a tradition in history of banning similar types of firearms or similar laws that can be comparable, not strictly the same exact thing, but relevant to this type of challenge? So we got rid of the loaded chamber indicator, magazine disconnect mechanisms, and microstamping requirements. Now keep in mind the state has 14 days to appeal this to the Ninth Circuit before it would take effect. If the state does not appeal it, a situation could look something like manufacturer like Glock with their Gen 5s sends their Gen 5 Glock off to the state of California to get drop tested, it gets added to the roster, they pay the fees. That's very simple. Every manufacturer would do that. That's what it's going to look like if the state does not appeal. Now, I want to give a big thank you to PORAC, the police officers. I'm gonna butcher that if I try to wing that off the top of my head, but PORAC is a representative body of law enforcement in the state of California, the largest, and they filed in support of our lawsuit. And they mentioned specifically that unsafe handguns, I'm putting that in air quotes in my head so you don't get too angry with me saying unsafe handguns, are commonly used and the most commonly used firearms by law enforcement in the state of California. So law enforcement in this state are using unsafe handguns. If they were trying to use unsafe handguns, clearly they're probably not unsafe. Specifically, I want to call out the fact that the state's own witness, the guy who runs the roster with the DOJ, he himself carries an unsafe handgun. He uses a gun that he was saying is unsafe per the definition in the state of California. Keep in mind, from 2007 to 2013, I believe it was, that was when loaded chamber indicators and magazine disconnect mechanisms became required. During that time, some manufacturers like Smith & Wesson and SIG added handguns with loaded chamber indicators and magazine disconnects. Great. We had some recent models up to May of 2013. And in May of 2013, the state of California implemented microstamping because they said it was technologically feasible and not held up by any patent issues, that any manufacturer could use this technology. Could, in theory. In practice, it ain't gonna work, which is why of the 832 handguns on the California handgun roster, only 32 of them have the features like magazine disconnects and loaded chamber indicators. But all 832 would technically be unsafe because they don't have microstamping, which is an odd thing for them to try to argue that they want unsafe guns to not be in the hands of private citizens when you can still own them. And the grandfathered firearms that are on this list are all legally defined as unsafe. 832 handguns, that's all we get. Most of those are color variations. So realistically, we might only have a few hundred handguns that we can actually buy, all of which prior to 2017 or 2013 for semi-auto handguns. Now, I want to give a little shout out to myself and Lance Boland. Some of our testimony did make it quoted into this recent ruling. So Reno May testifying that because of the high demand of off-roster handguns and the very low supply, usually being supplied by law enforcement or people who move from out of state into the state with one of those firearms, it is very hard to come by and is very expensive. They also quoted me saying that even when you want to find one, it's hard to come by. It's going to be difficult to actually go out and get it. And you're basically paying 2 to 3 times MSRP for a gun that might sell for $400 brand new in in any other state. You're going to be paying maybe $1,200 for that same firearm. Lance Boland testified on behalf of left-handed shooters. He is an instructor down in Southern California. If you are in the need for instruction, give him your business. He is fighting for your rights. Lance Boland testifying that left-handed shooters sometimes have to add steps of manipulation to the gun that if we had an ambidextrous firearm or a left-handed firearm, we wouldn't have to do, which takes time in situations where seconds or microseconds of time can be the difference between being able to use your firearm successfully, defensively, and potentially losing your life. Now, in order for a motion for preliminary injunction to be granted, you have to look at it and ask the question of whether or not this court case is likely to succeed on its merits. Now, we are proving that we are facing irreparable harm by not being able to own state-of-the-art handguns and are limited to outdated technology. And we're looking at the text, history, and tradition of these laws. Now, the state of California tried to make the argument that there are some analogous laws. They brought up proofing laws and black powder storage laws or powder storage laws. Proofing laws cover, back in the day, a manufacturer would make an individual firearm, and then it would have to be tested to certify that it would not explode and that it would actually shoot a bullet the specified ranges. That is much different than requiring certain features that don't prove whether or not the gun was well made. So kind of hard for them to argue, and the judge agrees that that is not analogous. Now, on the black powder storage laws were meant because storing large quantities of a combustible volatile substance can be dangerous because it can interact with the environment in certain ways. And it only covered specific ways of how much you can store it, how it needs to be stored, and that kind of thing, which in no way is relevant to owning a firearm that is perfectly safe and of modern technology. We knew that they were going to bring those up, and we were well prepared for that. Or I should say the lawyers were well prepared for them to make that argument, and it doesn't really hold up, and the judge agrees that it does not hold up. Obviously, the Second Amendment covers owning of state-of-the-art handguns, and that's mentioned in this ruling. Now, I want to quote something saying here. Similarly, if off-roster firearms were truly unsafe, California would not allow law enforcement to use them in the line of duty when the stakes are the highest. But the substantial majority of California law enforcement officers use off-roster handguns in the line of duty. And this was from PORAC, which again, thank you as president of the Peace Officers Research Association of California. And then in quotes, most agencies issue offers with the latest model of either Glock or Sig Sauer handguns, which lack the magazine disconnect, chamber load indicators, and of course, microstamping. For example, many are issued 4th or 5th generation Glock pistols, which are off-roster and lack magazine disconnects, chamber load indicators, and of course, microstamping. Indeed, the government's own witness, Special Agent Salvador Gonzalez, testifies that he uses an off-roster duty handgun without a CLI, MDM, or microstamping capabilities. If CLIs and MDMs are truly MDMs truly increase the overall safety of a firearm, law enforcement surely would use them, but they do not. Instead, they choose to use newer and improved, safer generations of handguns that are off-roster. An interesting thing to take away from this lawsuit that I really just blew my mind when he said it, this special agent actually said that removal of a loaded chamber indicator would be considered manufacturing an unsafe handgun. The state's lawyers did not question him on that. I disagree. Many people disagree. I've shown myself installing slides on guns that had loaded chamber indicators. Now with the new slide, it doesn't. I'm not arrested. Keep that as it is. I'm not a lawyer. This is not legal advice. Now, at the end of the ruling, he said, Californians have the constitutional right to acquire and use state-of-the-art handguns to protect themselves. They should not be forced to settle for decade-old models of handguns to ensure that they remain safe inside or outside the home. But unfortunately, the Unsafe Handguns Act, CLI, MDM, and microstamping requirements do exactly that, because enforcing those requirements implicates the plain text of the Second Amendment, and the government fails to point to any well-established historical analogs that are consistent with them. Those requirements are unconstitutional, and their enforcement must be preliminarily enjoined. Accordingly, plaintiff's motion for preliminary injunction is granted. So we got a dub. I'm going to be totally honest with you. My tempering my expectation of this was that we would get rid of microstamping. We got more than that. We got rid of loaded chamber indicators and magazine disconnects because of the hard work of the people at the CRPA and Michelle and Associates. That would not be possible without people like you supporting. A lot of you are asking, what are these organizations doing with our money? Let me assure you, and I cannot go too deep into numbers, they are operating with much less money than you think, and the lawyers are charging significantly less than they should. So your money is being spent well. Your money is being spent to deliver you wins. If you own Freedom Week magazines, it's because of the CRPA. When this all pans out and you can own unsafe handguns, it's going to be because of the CRPA. I am super excited to see this start off on a win. Remember, state has 14 days to appeal this to the Ninth Circuit. If they don't appeal it, boom, any manufacturer would be able to add their gun to the roster by just having it drop tested and added to the list. That's it, which would be awesome. This does not affect assault weapon stuff, so threaded barrels, things like that would still be an issue. But this is a huge win, and it's very important to start off fighting for a win as opposed to fighting against a loss. If you have any questions, drop a comment down below. Would love to hear your thoughts. If you want to support the channel, like, comment, subscribe, all that business. If you want to support the CRPA, donate to them, please. If you want to support the CRPA in other ways, watch their social media accounts, check out what their lawyers are up to, and just be involved, because that drives more people talking. Send this to a friend that lives in the state, send this to a friend that doesn't live in the state, because this lawsuit, I think, in my opinion, and obviously I'm biased because I'm involved in it, I think this lawsuit is one of the most important ones going on right now, because it's going to be the most easy to win in the public mind. Handguns are the quintessential self-defense firearm, and because of that, if we can get handguns again reaffirmed as legal and cannot be infringed on, then we can start taking bites at other things. Once we start winning handgun stuff, once we start winning about assault weapons, then the whole abolish the NFA thing becomes a little bit more realistic. So if that's interesting to you, support the people that are supporting you. Thank you. You guys know the drill. Have fun, be safe, stay dangerous. Peace.